Okay,
Okay.
press the button. And we're live. It is Tuesday, December 14th, 5:01 p.m. Eastern Time. We're not allowed to have fun anymore, but we
No.
are allowed to have the inestimable, amazing Yale law professor, Jack Balkin, here to talk about everything. I don't know. We're just going to have a nice talk about the Supreme Court Commission first, and then whole women's health and Dobbs and the whole everything that's been coming out of that. But how you doing, Jack? You hasn't been a while since you've been on the show.
I just want to ask you, as a technical matter, are you? Is my picture coming through? Because on my screen, I have a.
No, I can see you. You're fine.
All right. So as long as you can see me and hear me, we're doing fine. It's good to see you, Kate. It's great to be back on In Lieu of Fun, which, as you may or may not know, is the most famous talk show in the galaxy.
It is.
Yeah. There are people on Alpha Centauri, or sentient beings on Alpha Centauri, that regard you guys as basically almost semi-divine.
It's just, yeah, you always say the right things. This is why we keep inviting you back, among other reasons.
Of course, Centauri is several light years away. They actually won't get this broadcast for a while, but eventually they will be delighted by this broadcast.
Before we go to the Supreme Court Commission, I wanted to ask you. We were talking before we went in the green room about what you're working on right now, and you told me you're working on a book that is about how lawyers and legal scholars, or lawyers in like courtrooms, also practitioners,
lawyers, judges, legal scholars. Those folks.
use history in like the pursuit of making their argument, basically.
In constitutional argument, yeah. So it's about how lawyers argue about constitutional history and how historians shake their heads.
So why do they shake their heads?
Because they do not think of history the way that lawyers do. This is a topic for another In Lieu of Fun. But lawyers and historians have been going around on this for a long time now.
Great. Well, I would love to have you back to talk about that, and maybe someday, eventually.
There's some historians in the audience. I'm sure they'll tell you that the way that lawyers use history is not the way that historians think you're supposed to use history, and so there are a lot of different interesting questions.
Interesting. So tell us about. Well, first of all, tell us what the Presidential Supreme Court Commission was aimed to do, how many people. It was a huge panel. There were a lot of people. So that was right. It was coming. That was kind of, you had been on the show to talk about it, and I think initially right after you got appointed, and it hadn't met yet.
I couldn't talk about it because you're not supposed to. But now that the report is out, the final report is out, we are free to talk about it. And several of my co-commissioners have been writing op-eds in the Post and Time Magazine and other places. It's almost as if they can't resist talking about it now that they're free to talk about it. And they are. So let me just tell you the background of it. So if you think about Democrats and Republicans aren't interested in reforming Supreme Court. Republicans like Supreme Court fine. It's doing exactly what they're supposed to, what they wanted to do. It's really the people interested in reform are the Democrats. And the Democrats are deeply divided over this. And they were deeply divided over this during the 2000 campaign. So Joe Biden decided what he would do is he would promise a commission, but he would also promise a commission that basically wasn't going to make any recommendations. And so he designed this commission to basically talk about the pros and cons of different reforms for the court, but we were strictly enjoined not to make any recommendations. Instead, just basically do the analysis, the arguments pro and con. The reason is very simple. Biden's party is divided on this question. They're not all together behind it, and even if they were all together on it, they would have a great deal of trouble making any reforms under the current conditions, because first they have to get rid of the filibuster. Then they have to get the moderate to conservative Democrats on board for any reforms, even if they would pass the filibuster. And that's a lot of of ifs. So Biden understood that. Also, Biden comes into the presidency. There's just been a coup. There's
I've heard about that.
problem.
Yeah.
The economy is in terrible shape, and there are any number of different problems. So his view was he didn't think that court reform was actually his first priority. At least this is my guess, and that's why the commission is created the way it is. Nevertheless, this commission issued a report, which I think will be very useful down the road when there actually is political will to do some reforms in the Supreme Court. And even though the commission makes lots of arguments against reform, all the arguments for reform are still available. And when reformers get the political will together and get the votes together, then in fact, I think the commission report will be very useful. So that's what those who are reformers, I'm a reformer, on the commission thought. We thought, well, we'll do the best we can. And then later on, when the political will is there, people can use this. There were also people on the commission who weren't really interested in reform. So two of them, two former federal judges, Griffiths and Levy, just wrote an op-ed in the Washington Post in which they said, we don't see why there should be any reforms, actually. We like the courts just the way they are. Or we think it would be very dangerous to mess with them.
So you said courts just now. So was this about the entire federal court system, or was this about the Supreme Court in specifics?
It was primarily about the Supreme Court, but you can't really talk about the Supreme Court unless you talk about its relationship both with the lower federal courts and with state courts. So let me just give you an example. One of the chapters is about jurisdiction stripping and supermajority requirements. And you can't think about jurisdiction stripping or supermajority requirements until you think about what its effects would be on lower federal courts and state courts. So if you basically say the Supreme Court can't decide certain issues, well, what about the lower courts? They'll decide them. And if you say supermajority requirements, well, if there are a majority that want to do something but not a supermajority, what are lower courts supposed to do with that? So ultimately, you had to talk about it. And there was another elephant in the room in all of this, a point that I made repeatedly. I actually made it in the public hearing, and that's the Senate. It's my view that Joe Biden should have created a commission on the reform of the U.S. Senate because the U.S. Senate is
in its role in selecting judges.
It's where, as I said in the public hearing, the Senate is where good ideas go to die. The Senate holds up everything. The filibuster in particular, also the process by which judges are the hearings for the appointments have become a farce, and it's just basically a combination of realpolitik and brute force and crazy theatrics. Now, the Senate is really one of the major obstacles to not only reform of the courts, but most of the reforms that our democracy needs right now. But of course, the commission was not asked to suggest reforms to the Senate, although there is an appendix talking about potential reforms to the appointments process. Nevertheless, because many of the commissioners, myself included, felt that you just can't talk about reforming the courts unless you talk about the Senate.
So you had been on the show like many moons ago, to talk about a proposal that you had come up with that I thought was very can you summarize that again for everybody? And then just was that something that came up? Was that one of the reforms that people were kind of neutrally weighing here?
Yeah, so I have been a proponent of term limits for Supreme Court justices for, I guess, 20 years or so. I've signed various, letters and things, and I've written about it in my scholarship. So when the commission was formed, I was asked to be on it. I specifically asked to work on the term limits chapter, which is chapter 3. And so we dutifully rehearsed the arguments for and arguments against term limits, and we dutifully described different models of how you would actually have term limits, one of which is closer to the proposal I made some time ago. I'm happy to talk about term limits. I think many people saw the commission as primarily focused on questions of increasing the size of the court, but only a small number of commissioners actually worked on that. Most of us worked on different topics. Some worked on jurisdiction, supermajority requirements, legislative overrides. Some worked on term limits. Some worked on increasing the size of the court, and some worked on reforming the judicial ethics system, the access to the judges' oral arguments, and also what's called the shadow docket, in which judges without hearings, justices decide very important matters on an emergency and expedited basis, which many people have thought has actually undermined the quality of their decision making. So there were lots of commissioners working on lots of different topics, and the report that you see is the result of a combination of different working groups working on all these different topics, and then they traded the reports with each other. People made comments on the reports, and then they were redrafted until we finally got more or less a consensus on what the report should look like.
Yeah, and so let me put this in the chat again so that people can take a look at it. This is the final report from all of the commissioners. There are 5 chapters in the report, and I think that the majority of everything kind of talks about like the areas in which you're kind of are talking about proposals or chapters 2 through 5. Is that right, Jack?
That's right. And one is sort of an introduction to how we got in this situation. And it's a brief history of the political and social things that led to the call for a commission on reform.
This is an incredible kind of lineup of people that they put together that are on the commission. I think we've talked about that on the show before. It's just like 30 or 34, 35 of, just kind of brilliant legal minds and people with opinions.
I think the audience would be very interested. It was picked, tied to a particular conception of what it would produce. So, for example, there were very few people that are strongly identified as activists.
Yeah, I did notice that. Like, it is kind of neutral. A lot of people who are
law professors. It's mostly law professors. A couple of former federal judges, and you won't be surprised to learn the former federal judges didn't want to make any changes. They liked their jobs just the way they were.
Article 3 works for them.
A relatively small number of people associated with civil society organizations. Only one political scientist, Keith Whittington, who's a very fine scholar. And that's strange because if you wanted to redesign an institution, the people you would go to are not necessarily lawyers. They argue cases within the interstices of the existing system. You would go to a political scientist because that's what these people think about all the time, the design of political structures and their consequences. But there was only one political scientist. And it was also very important that there be political conservatives and Republicans on the court so that it could have a kind of bipartisan sheen to it. Although 2 of the conservative commissioners, left in the middle, presumably, I don't know exactly why, but they didn't like the current drafts at the time. I actually think that if they had stayed on, they would have been much happier with the final product.
Didn't Jack Goldsmith, was he considered one of the more conservative? I
don't know if he was conservative, but he is an establishment conservative. He's a very fine lawyer. He's been in government.
But he left though. He's not on the final report.
Yeah, I think he didn't like the drafts that came out. My assumption is, again, I don't know exactly,
sure.
But they had seen their own working group and they had come to terms with what their own working group was done. But then they saw the other reports from the other working groups, and I think at that point they said, well, we just have we don't know what's going to happen here. But again, I think that since both the opponents and the proponents of different views basically kept adding things to the drafts as it went on, I think they probably would be happier with the final version than the draft version they saw.
Interesting. So there had to have been some level in which people had opinions on what should or should not happen, and what should or should not go in, and what should or should not be discussed. I mean, this is one of this is kind of Evelyn Douek's everything is content moderation kind of approach, which is like deciding what goes into a history even or a report like this is just as important as like what you say once it's in there. Right. the mere inclusion of stuff. I mean, there had to have been some level of kind of heated. How did you even wrangle something within working groups, and then how did you wrangle that draft once it was disseminated to the rest? I mean, I don't know. It just strikes me as a lot of herding cats.
And another thing that's really crazy is the Federal Advisory Committee Act. The Federal Advisory Committee Act it governed how we could do our jobs, And one of the crazy things about the Federal Advisory Committee Act was that it divided our work into public meetings and then into other kinds of working groups in which we actually weren't in touch with the other commissioners. So we were often like 5 little spaceships doing our work. And then the spaceships would get together for these public meetings. But the public meetings, it was just really not possible to have the kind of discussion you would want to have when you want to talk in detail. And that's what the working groups were for. So in other words, there are really interesting and for law nerds, really complicated problems about, the constitutional questions of whether you can, by statute, basically create the effective equivalent of term limits, as an example. There are a lot of really difficult technical questions. You would love to be able to talk to the other commissioners about them. We really couldn't, because the Federal Advisory Committee Act basically prevented us from having these kinds of conversations. All the conversations of the commission as a whole had to be in public, and then it was an extremely stilted system of the public hearing. So all the work had to be done, the nitty-gritty had to be done within the working groups, and there it really was a very, very serious conversation. I should also point out that not only did people fight over the content of the topics they would discuss and how you would solve them, they even fought over there was even a dispute as to how to characterize the court packing plan during Roosevelt's administration. And people had very strong views about what actually happened and how to characterize what happened and what the consequences were of that. And you won't be surprised that their views about the history mirrored their views about today. That is to say, depending on your view of whether you think court packing is a good idea today, your view of what happened in 1937 is very different as well. And that's, of course, related to the book I'm doing on how lawyers use history in constitutional argument.
No, this is such a great point, because I feel like this is something that I am even still fully coming to grips with now that I even teach law, is that I'm trying to make clear to all of my students that a case is, to a certain extent, whatever it is you tell the judge that case stands for, and all, your interpretation of the facts is there, but you can pull out certain things as long as, without being dishonest and within the bounds of ethics, but that.
But these folks, by the way, they weren't basically trying to nudge the facts. They were basically asserting their view as to what actually happened. There was one of the things that was submitted.
Give me a for instance. I actually just had this really lengthy argument, just with Genevieve Lockyer about what Marsh v. Alabama meant, in which she for example, I just thought this was cookie cutter. This is kind of more or less how the state action doctrine approaches the Marsh question. I didn't think there was that much, and she just has it's not that my view is wrong. It's just that she has this incredibly different flavor of what it means in vis-a-vis the entire rest of the Supreme Court's decisions before and after.
Well, here are some examples of historical questions. And then I'd really like to hear the questions about, the actual substance of court reform today.
Yeah, of course.
Examples of questions people would disagree about. So one question would be, was the court packing plan a failure? Was Roosevelt, was the Senate report, which criticized it, an important document or not an important document? It actually turned out that Senate report backfired. It had exactly precisely the opposite effect. Did the court packing plan essentially destroy Roosevelt's domestic agenda for the rest of his presidency? Is the meaning of the court packing plan that there is now a norm that you don't try court packing anymore? These are all historical questions, but they're also questions about meaning. What do things mean? What's the larger significance of these events? So there are disputes about facts, and there are also disputes about what they mean. Let me give you a simple example. It actually turns out at almost any point in the spring, in June of 37, Roosevelt could have said, I want 2 justices. I'd like you to get Justice Sutherland to retire, and then that's it. I'm going home. And he could have gotten that. He actually could have gotten 2 justices and probably a 3rd retirement. He also had a retirement in the bag because Vandevanner had retired, announced his retirement in May. So he could have 4 appointments, but he wanted more. He actually wanted a much larger court packing plan, and ultimately his holding out for even more is what sunk it. And also another problem was the Senate Majority Leader was a conservative Democrat from Arkansas named Joe Robinson. It turned out at the worst possible time, he had a heart attack and died. And he was the primary champion of the plan in the Senate. When he died, it's been about 2 weeks later, basically everything unravels.
That's
So
pretty inconvenient.
it's all contingent. And so therefore the meaning of it is heavily contested. Now, I actually happen to be opposed to court enlargement for reasons I'll talk about later. But my view is that the history doesn't show that the court packing plan was a complete failure. It shows that Roosevelt just overplayed his hand. It's also true that after the court packing plan, Roosevelt's domestic agenda falls apart, but it's overdetermined because, first of all, he tried to purge Southern Democrats from his own party. That didn't go over well. And then there was this little thing happening in Europe called World War II, which was basically brewing. And that also diverted attention. And he also misplayed his hand on economic policy. There was a recession in 38. So all these things together basically, undermined his domestic agenda. So it's difficult to say it was just the court packing plan. But these are the kinds of debates historians have and continue to have. For them, history is complex and multifaceted, and there are a lot of contingencies. But for lawyers want a simple answer. Was the court packing plan decisively refuted, and was it the cause of the destruction of his administration or not? Yes or no? Please tell me, because I'd like very much to take a position on court packing today. That's how lawyers tend to.
Yeah, but this is the entire, so this is interesting that you're writing this book on this, and I'm glad that you prefaced actually that you're writing this book, because I feel like it really kind of frames a little bit this conversation. So like when you had all of these lawyers kind of discussing this, or these legal scholars versus historians, but discussing this history, like one of the things that I find really frustrating, as you know, or that I find, I don't know, that I struggle with legal scholarship is the desire to come out in a normative framework at the end of the day, instead of treating things in a historical way or a descriptive way. And that I'm it's unclear to me why legal scholars want this so badly, except that like that the practice of law is outcome based in certain regards.
They're advocates for normative, not only normative positions, but prescriptive position. This is what we should do. This is what we shouldn't do. And so history for lawyers tends to be of two types. That is, the history shows definitely I'm right and we should do this, or, the history is very complicated and you really don't know what it says. And so you can't draw any important conclusions from it. And lawyers do both of these things, and they do them, they just flip back and forth from one to the other as the occasion calls for it.
Man, I am in the wrong line of work, Jack.
This historians drives them nuts. They just can't believe that lawyers can get away with this stuff. But that's what lawyers do.
No, it's true. I think that's right. I feel that way a lot of times. But okay, so let's get into the decision, into the report. And so what you said that you worked on the section, I have it open. You said that you worked on the term limit section, which is large. It's 6 subsections and it's roughly 40 pages. So what went into that? Was there specific things that you can talk about that didn't? How many meetings did it take to write those 40 pages?
We met pretty regularly to talk about it, about an hour at a time. But the key issue you want to ask yourself is whether term limits are a good idea. It turns out term limits.
No, it's not. I don't need a should. But I thought the entire thing was you weren't supposed to tell us whether it was a good idea or not, Jack. I thought you were specifically directed.
I'm not the commission. I'm the guy who worked on the commission. I have very strong views about all of these things. You can ask me, I'll tell you. Whereas there were other commissions.
Oren Kerr on Twitter had a very funny quip about how the commission all agreed, 34 people all in the same report, and then had issued 34 different op-eds in every single publication on the planet over the next couple of weeks. But so specifically when it came to term limits, what were some of the things that you think should be going on or should be happening? Did your mind change?
No, not really. I got a much better sense of the constitutional problems and a much better sense of the implementation issues, which really are the major argument against term limits, is that it's going to be very difficult to implement.
But just
But
because of the politics right now in the Senate and the House, or like what? Or actually once
you have to. So if we started from scratch, term limits would be very easy. But you have existing justices on the court, and the question
right.
you want to ask is how are you going to integrate them with the new system where the president makes 2 appointments in each term, and so for a while you're going to have a much larger court. So if you have a term limit system and you grandfather and I use that term advisedly, the existing, then what's going to happen is the court will get larger for a while, and then it'll eventually settle at the appropriate. There's another issue, which is how many. So if you have 18-year terms and you make an appointment every 2 years, it'll eventually settle at 9. If you give them 12-year terms, then what's going to happen is a president's going to appoint more. Are going to get to appoint more over the course of their terms. There's actually a formula for this, but that gives presidents much more power. So one thing you have to decide is how much power do you want to give presidents to basically shape the court. So imagine that you're elected for 2 terms. If you have 18-year terms, then a president can basically appoint 4 justices, which is not actually that unusual historically. A 2-term president, yeah, a lot of them got to appoint about 4. But if you have 12-year terms, then in fact it's going to be a lot. It'll be 6, I believe, that you can appoint over 2 years.
Would it have more political viability if you did something, for instance, like promise a certain number of appointments to the next president of an opposing party? Like, is that something that is even possible? I don't even know.
There are a bunch of constitutional issues as to how you can change the president's and the Senate's roles. Almost anything can be done by amendment, but I was interested in how it could be done by statute. There's a real problem here, a very important problem. You won't be surprised to learn it's the Senate. Let's suppose that the system in which you promise that the president gets 2 appointments in their first and third years of the presidency. So that works out to a court of 9 justices with 18-year terms. That's how the formula works. Now let's suppose that the Senate is run by someone, let's just call him Mitch McConnell. And Mitch McConnell says, I'm not going to give you an appointment in your first term, and I'm not going to give you an appointment in your third term. I'm going to just keep stacking them up until I get somebody from my party president, and then I'm going to get 4 appointments. I'm going to get the ones you didn't get and the 2 that my guy gets, and then the result is it defeats the whole purpose of the system, which is to make sure that each president, when they're elected, gets 2 opportunities to appoint justices. And that will, over time, make the court much more responsive in the long run to the larger flow of American politics. I mean, one of the things that's very important in understanding how we are now, and here I'm speaking from the perspective of liberal Democrats. Republicans are just happy with this. But liberal Democrats think to themselves, well, Carter got no appointments, and Trump got 3 in 4 years. Obama should have had 3, but he only got 2 because Mitch McConnell kept him from getting 1. And as a result, Democrats basically don't have the same influence on the court's membership that they probably should have had if it was a system that was run fairly. That's what Democrats would say. Republicans would say, what are you talking about? What are you talking about? It's just crazy.
I actually kind of think that there is so I have a question. So I want to know if this was contemplated. One of the things I'm super intrigued by is that there are 2 I'm pretty sure this happened, that there were 2 Second Circuit judges who have stated that they're waiting to take senior status, or they were waiting to take senior status to see who is elected president, and then they want to have some type of knowledge of who is going to be considered for their
strategic retirements, and when you have life tenure, if you have life tenure, then you have strategic retirements. If you have term limits, it's much harder to do strategic retirements because basically
and so
18 years, and you're not going to retire early. You're going to stick it for 18 years because most justices like being justices. So you get rid of the problem of strategic retirements if you move to term limits. That's one of the arguments for it.
But do you think that history tells, given everything we've said about history, do you think that there is an increase in in how judges in the lower courts, or I mean, like, let's leave the 9 out of it for a second, but like the judges in the lower courts are doing more strategic retirements?
My
Because
sense is that judges in lower courts have always engaged in strategic retirement. But I am less worried about that in the lower court than I am in the Supreme Court. Let me explain why. This is a point that came up in the public hearings, a point I made in response to David Levy when he raised the fact. He says, well, if you're going to have term limits for Supreme Court, why not for lower federal courts? And he would be opposed to that. And I said, it really makes a big difference. There are approximately 800 to 900 federal judges at any one time. There are only 9 Supreme Court justices. So if you have a large enough sample, 800 to 900, then you can be assured that over the course of a presidency of 2 terms, a significant number of them will retire. They just get older, and their ages are distributed, and all sorts of things happen to them. It's a large enough sample that you can expect there will be a regular rotation in the lower federal judiciary, even with life tenure, and that's what we see.
Yeah.
But when you have a sample of only 9, then in fact you can't be assured that Mother Nature and Mother Time will actually do their work and guarantee a continuous rotation of people in and out of office. Instead,
and suddenly out of nowhere, one of them kicks the bucket, and then you're all of a sudden like, yeah.
And so it's very unpredictable. It's very contingent. The advantage of 18-year terms is that everybody knows how the game is played. You're gonna, and you can appoint people who are a little older. You don't have to appoint very young people because they're not going to be on for more than 18 years. And so if you have a distinguished jurist, you can appoint someone who's older because, in fact, they'll serve for 18 years. So there are all these advantages. It also means that as American politics changes over time, the justices will stay much more in sync with the basic tenor of the values of American politics over time. And it will be, I just think it'll be a much fairer system than the one we have. In fact, we have a natural experiment. The natural experiment is the history of the United States until 1970. Until the middle of the 70s, basically, what we had was something that was almost equivalent, not exactly the same for complicated reasons, as the idea of 18-year terms. On the average, the justices would stick on around for about 18 years, maybe more, some less. There would be some that lasted much longer, some much shorter. But what we noticed was that the system worked pretty well. And then in the 70s, late 70s, it's really after Gerald Ford and Carter's presidency, they just stayed on much longer. The terms averaged much longer, and presidents got fewer chances to appoint. And so that's largely a real sea change in the way the Supreme Court works. And it really corresponds to the period after the middle of the 1970s.
I'm fascinated to know what the opposition to term limits is, because it does seem, unless you think that the deck is stacked in your hand currently and is going to stay there forever, it seems like, logistics aside, that there should
made against term limits, which I don't agree with, is that by making the appointments work like clockwork every first and third term, you make it look like the Supreme Court justices are the mere pawns of the parties or of the presidents.
And it becomes more political instead of less. It becomes more
political. And my view is that's based on a very unrealistic view of how the system has operated to this point in time, and that in fact, in some ways, it lowers the stakes, because you know that now, if a Supreme Court appointment comes up, there's an enormous amount at stake, because you never know when another one's going to occur. And therefore, you just pile everything on into either blocking or getting the person on. Whereas if you know that they are coming first and third years of every presidential term, you got to win the presidency. If you do, you get your justices appointed. You get appointments. It just changes the game. It just makes it a very different world. And it also encourages turn taking. The current system does not encourage turn taking. The current system encourages get your stuff while you can, so the other guy never gets his stuff, and you devil take the hindmost. It's a system that's really designed to increase partisan rancor. Term limits would not cure partisan rancor, mind you. It wouldn't solve the polarization problem, but it's certainly a much more rational system.
I mean, there's also just, I mean, it's not just much more rational. It does serve other things that we hope the law solves for, like giving us predictability and stability over time, and kind of like knowing, I mean, even though that's not typically contemplated in the makeup of the courts, like I think that that is like something that is important. I mean, people decide when they're going to bring certain types of cases based on the makeup of the court, or like or the make or what circuit they want to bring it in.
Generally
So
the way people about it is you have a sense of the judicial philosophies of the justices. Even though the justices are not mere pawns of the party system, they don't just vote one way, whatever their party tells them. That's just not what they do. And they don't think of themselves that way. Nevertheless, have a good sense of what their judicial philosophies are. You know that Amy Coney Barrett is an originalist. And she's a political conservative. And so that you have a pretty good idea of how she's going to think about a lot of problems, not all. And as time goes on, she's going to change her mind about some things. But generally, you have a fairly good sense of what's going on. That's not the same thing as saying that these are mere adjuncts of political parties. It's just not the same thing. But it does mean that each president should get the opportunity to find judges who represent the president's judicial philosophy, and also the judicial philosophy of the coalition that supports the president. That's, in fact, exactly what the Republican Party has realized and succeeded in doing over the course of the last 4 decades or more. They have sought to put judges and justices in place who reflect the judicial philosophy and constitutional values of the movement conservatives and Republican Party. Been very successful at it.
So I want to talk for a second about I want to get into we're edging up to whole women's health, I think, and some of like kind of what happened, both in the decision, and then I think oral arguments, which were both interesting. But before I get there, I'm kind of curious, just like to kind of like wrap up a little bit the discussion on the report. Given, I know, and we know you like term limits, but if you were just really kind of like taking a step back and being a little bit neutral about this and kind of reading the whole report together, if there were going to be recommendations that came out of this, what do you think are, I'm not even going to say, okay, so let's set aside political feasibility, but like what in the kind of the gamble and the measure of whatever it would mean to be politically feasible and instrumentally possible, like, are the best idea?
Well, it all depends.
Are you going to say term limits?
Well, do you want to? So let me try and put this in perspective. Term limits are quick fixes. That is, you think there's something deeply wrong with the court and needs to be fixed immediately, and that's how you're going to. A court expansion is a quick fix. Something's deeply wrong with the court, you got to fix it, and so you have to have 4 new justices to the Supreme Court. And everybody who argues for a court expansion is arguing that way. There's an emergency. The court is gone haywire. These are all Democrats, by the way. Republicans don't argue this way.
No kidding.
And we have to do something. Our democracy at stake. If we don't do something now, who knows what will happen? We need court expansion now. Term limits folks are not quick fix people. They're people who think, well, the court is out of whack, it's out of balance, not partisan balance. It's just very random. It's just a random situation where if somebody has a heart attack, then the direction of the whole country changes. And it just is an excuse for partisan hardball. So term limits folks say we ought to have good government reforms that basically make the system work better and is more predictable and rational. But it's not a quick fix, because in fact, a term limit system, if you put it in place, would take some time to have its effects. So term limits people are thinking around the long term. They're thinking about similarly, and then jurisdiction stripping people. Jurisdiction stripping people, their view is,
that's a very long term.
I don't like the Supreme Court's making these decisions. Let's stop them from making these decisions. So let's strip their jurisdiction now. So a jurisdiction stripping people, they have a bunch of things they want to do, and they want to do it now. Supermajority requirements people are basically thinking about long-term structures, but I don't think they know exactly what the consequences will be, but that's what they're thinking in terms of long-term structures. And similarly, people who want things like legislative override, which is what you have, something like that in Canada, they're also thinking in larger structural terms on the long haul. So among the people who are involved in the report, some are thinking, I need something quick, and some are thinking, I want something for the long term. I'll give you a wonderful example. Larry Tribe, for many years, like me, was supportive of term limits. But by the time he finished working on the commission, he said, I no longer believe in term limits. I no longer think it's a good idea. We need court expansion now, says Larry Tribe. Well, I think I know why that is the case. I think that Larry Tribe thinks that American democracy is in deep danger and he wants a quick fix. And so that's why he supports term limits. I think he also has objections to implementation of term limits, but that's why he wants court expansion. I'm sorry, he supports court expansion, not term limits. And so it just depends on what you think. How do you understand what's going on in America? Do you think that we are in dire, dire trouble? I think we are, but I don't think that court expansion is the answer to the dire, dire trouble that we're in right now. I think that what you have to do is you have to fix the Senate filibuster rules, and you have to have significant mobilization to basically put people in place who will pass really important reforms to our democratic system. That's what you really need.
So the shadow report for the commission is the Jack Balkin shadow docket is the Senate. It's actually not a report about not the commission. It's not about the Supreme Court at all. It's about the Senate. That's like
the Senate. The Senate is a well, I won't use the word disgrace, but it's a major obstacle to the preservation of our democracy. Our democracy is in deep trouble, and the Senate stands in the way of fixing our democracy.
Yes, I've heard this said a few times. But I want to just really quickly before we go to questions, I want to hear if you think any of the things about what you saw or were afraid of when you went into this commission, and as this report was coming out, how you like what you thought about the oral arguments and then the result in Whole Woman's Health. Like, I'm curious what you thought.
Well, okay, so Whole Women's Health is decided in the shadow of Dobbs. Dobbs is the Mississippi case in which 5 of the justices strongly signaled they wanted to overturn Roe versus Wade and the Casey decision. Mm-hmm. So you can't understand what's going on in Whole Women's Health v. Jackson, except against the background of the fact that it's very likely that 5 justices don't think there will be a right to abortion come June. And therefore, they don't regard what Texas has done with any degree of urgency. They don't see it as a serious blow to the protection of constitutional rights in the United States, because in their view, this thing is going out the window anyway in several months. So why should we make a big deal out of this? So it turns out that the justices who were in dissent in Jackson, that's the Chief Justice and the 3 liberals, are the justices most likely to not want to directly overrule Roe versus Wade. I think the Chief doesn't like it, but I think he wants to proceed in slow steps. And the 3 liberals don't want to overrule Roe and Casey at all. And they're the ones most upset about the Texas statute. And that's basically my take on it, is that it's shadow boxing over Dobbs. Dobbs is the central question. Now in Texas, it is the case that one of the other things about it is that the people that are most affected by it are the people who provide abortions, because although they can sue some executive officials, they can't be assured that no individual plaintiff, no private citizen won't sue them for a minimum of $10,000 in civil damages. Yeah. And so they basically shut down because they can't risk it. And again, Dobbs is very important, because even if you thought that you would be vindicated in a lower federal court, they would say, clearly this civil lawsuit can't proceed because of Roe and Casey. In June, by the time the case is decided, Roe and Casey may not be there anymore. So why would you risk it? If there's no Roe and Casey in June and you're an abortion provider, it is folly to basically let somebody sue you, because there will be no right in June. That's why all of this is done in the background, in the backdrop of Dobbs.
So what do you make of Gavin Newsom's PR stunt, or
Well,
I mean, do
so,
you think it's a
again,
PR stunt, or do you think it's a real threat?
well, who knows? But again, it's really, this is a point Mike Dorf made, so I want to give him full credit. Again, Dobbs is crucial to understanding the difference between a statute directed at guns and one directed at abortion. In a statute directed at abortion, if you are sued in a civil lawsuit, you're an abortion provider and you're sued, you have to take the very significant risk that when they finally get to the merits, there's not going to be a right there anymore. But on the other hand, if you are a gun manufacturer or somebody who sells guns, and you get caught in a civil lawsuit, you know that there are 5 and possibly 6 justices who think that the right to bear arms is extremely important and will in fact protect your rights. And there are any number of lower federal court judges appointed by Republican presidents and Donald Trump who think that this is a very important right and they will move heaven and earth to protect your rights.
Is this jawboning? Is this California jawboning, the Supreme Court?
No, I mean, I think the really interesting question is, Newsom
maybe we need to come up with a new word for it, but you do understand what I'm saying, right? Like they're basically saying, like, listen, if you do this, then we're coming at you with this, and you're going to have to be inconsistent in some fundamental way with like.
Yeah, but I really don't think the justices in the majority in Jackson really care about whether they're called inconsistent or not. I think that they know where they want to go and they're going to go there. That is at least my current understanding of what's going on. They could surprise you. I should just tell you that when I was working on a book on Roe versus Wade, which is now sadly out of date, it was called What Roe versus Wade Should Have Said. And it was published in 2005, I think. And it had all these opinions rewriting Roe. It would be an interesting question as to whether this will be a historical artifact next year. I did a lot of research on the history of the decisions in Roe and Casey, and I went to the Library of Congress and I read Justice Blackmun's papers, which had just been opened to the public. And I discovered that, Roe was going to be reversed several times during Blackmun's term as a justice, but it didn't. As I say, it was going to be reversed in 89, it didn't. It was going to be reversed in 92, it didn't. And, things happen. And it's possible that things will happen in this case, but I seriously doubt it, because I think it's a different group of justices that were on the bench in 89 and 92 than today. And so I think the justices today are more predictable, I think, than the justices in 89 and 92.
Jack,
Scott
do you know?
Shapiro, I am so delighted to see you.
Thank you for letting me come on the show.
You're like a co-host. Jack was very excited. He was like, I've never seen Scott co-host the show. I'm like,
okay.
I really like Scott, and he's also my colleague. And because of COVID, we don't get to see each other very much anymore. And so it's just lovely to be able to talk to him.
Great.
So did we resolve the question about whether the commission made the right or wrong recommendation?
Yes.
Yeah, we resolved that.
Okay.
Yeah, we resolved, as Orrin Kerr, I gave credit to Orrin, that his 34-0, the commission puts out this report, 34 different op-eds and 34 different publications. And then he went back on that though, Jack. He was like, well, maybe it wasn't 34 different op-eds because actually they co-authored some of them. So
I decided instead of writing an op-ed, I would appear on in lieu of fun, and that way I can have a conversation with you guys. So one less op-ed.
We have a quick question from David, and so I'm going to have David come on really quickly and ask his question. If we can get if you can get him to pop up, I think we can hear you, David, but your camera's not turning on.
Can you hear me?
Yep.
Okay, I'll ask my question. So everybody always talks about how hard it is or impossible to get an amendment passed to deal with term limits and or any of the limits that you talked to, any of the terms that you talked about. So I wonder if Congress can do this by extortion, essentially. Congress can pass a law in, let's say they could have passed this early this year, saying we're going to add 2 justices to the court every year for the next 3 years. And at the same time, we're going to try to pass this amendment. that has term limit, 9-year, 18-year term limits and so forth. But and so justices will start to be added by Biden, and that will incentivize the red states and the red state senators to vote for the amendment. So by extortion, you can force states to want to pass that amendment. So can you do that?
I'm not sure that's the way you would do the extortion.
I like the way David H. thinks. I like it.
But here's another way of doing it. So I am of the view, and so is my colleague Akhil Amar and Scott's colleague Akhil Amar, that you can actually do term limits by statute. That is perfectly constitutional. So one way you could do this is, and make sure that the court basically accepts term limits so they don't strike down the statute, is you could say the following. You pass a law with two parts. Part A is a term limit statute. Part B is a court expansion statute, and Part B comes into effect if Part A is held unconstitutional by the court. So it's a severability.
Scott's nodding like he has any idea what you're talking about.
No, that is really devilish. That's really clever.
You mean like something a lawyer would do? Is that what you're saying?
Yes, it's really. No, it's whose idea was that? Was that your idea? Very nice.
I'm not the only person who's thought of it, but yes, that is one of my
But it's
ideas.
a good idea. I want to, Genevieve has so many beautiful questions that she posed, but she wants to, I'm going to ask this because it got upvoted so many times. Like you mentioned this before. What do you think? You said like people don't like term limits because of political polarization, but her question is kind of, or you said that basically like you think that people say that term limits will make the court kind of more politically gamed.
That is
right?
to say, this will make it look like the justices belong to the presidents who appoint them. That was the argument against it. I find this argument mysterious, but that is